Franklin Drazen is with us this week, and he is going to present the second part of our series. He'll be walking us through the PowerPoint that you can view on your screen. And what we're going to do is keep everyone's mics muted, but you can use the chat function down at the bottom of your screen to type in a question as we go along, and I will be relaying that to Franklin. And then at about 1:30, we will open this up to a Q&A, so that if you have a burning question that we haven't hit on, you can ask it at that time as well. And for those who don't know, Chapel Haven Schleifer Center has been in the special needs field now for almost 50 years, and we serve adults with a variety of disabilities. And our mission is to teach them how to live independent and self-determined lives. So you can always learn more about us at chapelhaven.org, and you can join us at one of our virtual open houses, which we are doing every Wednesday at noon Eastern Standard Time. And it's a great time to meet our students and our staff and learn more about all the various programs that we offer. But at this time, I'd like to introduce Franklin Drazen, who is with the Drazen Rubin Law Firm, which is located in Milford. And both Franklin and his partner, Steve Rubin, who was our presenter last week, are certified elder law attorneys. And they have tremendous expertise in this field. So I want to thank them for joining us, and let's turn it over now to Franklin.
Okay, thank you. Last week, my partner, Stephen, went over a good deal of special needs law for people. And today we're going to tackle a slightly different question, which is, as a parent or having a person with special needs as a loved one, we're always concerned about what are we going to do to take care of them when we can't be around. And so today we're going to be talking about the most appropriate way to set aside money for loved ones, which is using a special needs trust. All right, so there's three basic rules I always like to go over when people start any kind of planning. And one is that everybody needs a plan. And even if you don't have a plan, you have a plan. You just don't know what the outcomes are necessarily going to be. The other thing I like to point out is there's not a right and wrong answer to how you do this. So even if something may provide some benefits for you, it may not be something that you're comfortable with doing or doing at a certain time. So only do what you're comfortable with. And if you follow those three things, you'll always have peace of mind at the end. So to do successful planning, we want to make certain that we set goals early for what we're trying to accomplish. It's very appropriate to write down the goals, so when you get to talk to an attorney about it, or if you're discussing it with other family members, you'll be able to address what their goals are. And as you study your options, you'll then be able to see which of those options that you have, because you all have choices, is going to help you reach one or more of the goals that you have. And when we're through with that, then you have to make a decision about what your plan's actually going to look like. And finally, we have to implement the plan. Now, there's a couple of things with implementing this kind of plan. Generally, when we do a trust, you have to have a trust document, and it has to be executed by the trustee and by the by the grantor who's setting up the trust. But that's not generally enough. We have to worry about funding, because the trustee only controls assets that are part of the trust. So if we don't have the assets in the trust, or we don't have a way to get them into the trust upon our passing, all that document's going to do is, is essentially worthless. And when we're talking about special needs trust, a lot of times we need to get the trust approved by a regulatory agency. In most states, that's the Social Security Administration. Here in Connecticut, we also have to get many of those agreements approved by the Attorney General's office. Now, not every kind of special needs trust may need to get approval in all circumstances, but generally for SSI beneficiaries, they will have to get that approved, because otherwise the assets in that trust will be considered belonging to the beneficiary, and the assets in the trust will then disqualify the person from receiving SSI benefits. So we went through what a trust is basically, but just to identify the parties, it's a written agreement. There's a grantor who sets up the set of instructions that the trustee is to follow, and sets up the limitations on what the trustee can do. And those instructions are what's going to define it as a special needs trust. All right. And the key about doing this is to set up a trust in such a way that the person on benefits can continue to receive needs-based benefits. All right, we went through that. So generally with a special needs trust, we're trying to provide for those extra needs that aren't covered through public benefits. And usually the trust itself will say that we don't want the trustee, or they're not allowed to use them for any benefits that would be provided by a state agency or federal government, or that may otherwise be providing them. So when we start looking at the law, these are some of the sections in the U.S. Federal Code that deal with related topics to the, and most of the law is contained within the Social Security Act, because before about the 1980s, there was no really such thing as special needs trust. It was when Congress enacted the rules that allowed assets in this types of trust to be disregarded in eligibility purposes that we began the era of special needs trusts.
So Franklin.
Yes.
Can you take a pause? There's a couple quick questions.
Okay, let me just, can you see a drag and dictate bar across the top? No? Okay, good. I'm just going to close the program down.
Oh.
Okay.
So Julie would like to know, Julie, hang on. Do SSDI beneficiaries need approval from SSA?
We're going to be getting to that.
Okay.
And the answer will, all right, the answer is generally no. All right, but as usual, things can be
Tricky.
answered. I'm having things pop up on my screen, and I'm hoping you don't see any of them. Okay.
No.
So,
and then Tina was wondering if you could please repeat about what would disqualify SSI benefits. Does that make sense?
all right. Well, generally there are assets and income limits associated with these programs that go up annually. So federally, for the asset limit, it's $2,000 under Social Security law. And that applies for at least 39 states because they have to follow their guidelines for eligibility purposes. But in a few other states, we're allowed to deviate from those rules. And these are generally states that had similar laws in place before the federal law was enacted. Connecticut is one of those states. And the limit for assets in Connecticut is $1,600. And generally that's at the end of any month.
Okay.
So if we have a trust of any substance at all, if we have to count the assets, it's going to get us over the $1,600 limit and cause ineligibility. On the income side, if we exceed the income limit, then it can, or we have to count the income, it can reduce the benefit. You generally on a dollar for dollar basis, especially if it's cash, that's a very strict rule. And then if we reduce the benefit to under, to less than zero, then we also lose Medicaid benefits that go along with SSI.
And you had said that you have to have your special needs trust approved by a regulatory agency. So
Generally, that's the case. There are some exceptions. There's one kind of trust, which are usually the type that would be, that uses other people's money, not the beneficiary's money to fund the trust. And oftentimes those don't have to be approved, especially in Connecticut. All right. You have to report the income if the person's receiving it from the trust as a source of income. All right. So if we can get back to this.
yeah. Because we had a family in New York that has a trust that's never been approved by anybody. And then another family asked about Mass and another family asked about Texas. So you hit on an issue there that people are interested
Yeah,
in.
if they're not what we call 409B states, then they have to be submitted. Now, when you submit the trust for approval, and you shouldn't be doing special needs trust by yourself, and you should be going to someone that does them regularly and has experience with them, because the Social Security Administration oftentimes doesn't write back saying this was okay, or if they deny the eligibility for the trust as a special needs trust, they won't necessarily tell you why it didn't cut mustard with it. Okay.
We had one person say, let's keep going with the presentation. So
Thank you, because some of these things will be revealed to you as we go along.
yes.
Okay, so this gets back to the SSI, SSD distinction, because a crucial distinction when you're going through these programs is to determine what type of program it is. If it's is it an entitlement program or is it a welfare program? Welfare programs are needs-based, which means they look at the assets and the income of the individual. And if they exceed eligibility limits, the person will be denied benefits. All right. Entitlement programs are different. They're done and people are eligible for them on a basis other than their finances. So, and the easiest example for these is that SSI is a welfare program. That's why we have to be concerned about, the person's assets and the income being included as theirs. All right. However, SSDI is Social Security disability income is based on someone's work history. So it's possible for someone when their parent, a person with disability whose parent is, that qualifies for SSI, when their parent dies or retired, they'll receive a larger benefit based on the parents' SSDI or retirement payments. But it doesn't matter for SSDI purposes how much the person has in assets. You don't have to be poor in that situation to get SSDI. You have to have it, but they're always based on someone's work history. All right. So even if it's a person with disabilities that's receiving it through somebody else, as most people that had the disability before they reached age 18 won't have any kind of a work history, they can still get SSDI through a parent. And if they do, and that's the type they're getting, then it doesn't matter what their assets are. Now, I like to say it doesn't matter what their assets are at the moment, okay? That doesn't mean that down the road or for another program, because if the person has too much assets or income coming in, it can make housing unavailable to them under Section 8 and things like that. So you have to look specifically at the program that you're looking for. So let me move on. So the next thing is, why do we need them? And as I mentioned before, we don't want these assets that are set aside to take care of our loved one to be, counted as theirs. But that's not the only reason why we use special needs trust. We use trust because many of the people that are the beneficiaries aren't going to be able to either manage the assets in a way that will preserve them and make certain that they get used for the most appropriate purposes. But I've had beneficiaries of special needs trust where there was an option whether or not we should give the money directly to them or whether or not we should have it in a special needs trust. And in that case, the family was afraid that she was such a nice, kind person, influenced so easily by so many people, that she wouldn't be able to hang on to the money for an hour once somebody found out that she had it, because she'd be giving it away to people. So keeping it in a trust protects it. It protects it from their benefits. It protects it from their potential creditors. So there's many things. It protects them in the case of a divorce from becoming part of marital property in most states. So there's a lot of other reasons why we use that. All right, so we touched on income sources for people with disabilities. So supplemental security income, we said, is a welfare program based on income and asset limitations. SSD or SSDI is not. Earned income is another source, and that's income that you get from working. All right. Unearned income are things like dividends from bank accounts, or stock, and interest, and rental income from owning real property. All right. Now, in the SSD situation, earned income's not a problem. All right. And I don't have time to go through a lot of these things about the various individual programs. But for SSDI, if the person makes too much income, they can be considered substantially gainfully employed. And if they are, then they're not considered to be disabled anymore, regardless of what their disability may be. All right. And there are inheritances. Let me go back a bit. So with inheritances, if they go directly to the individual, that creates a problem because they have to report under SSI any amounts that they have received that aren't known by the Social Security Administration. And in Connecticut, the Department of Social Services would generally be involved as well. But in most states, it's the Department of the Social Security Department or Administration that deals with those kinds of distinctions. In Connecticut, we have the Department of Social Services also involved. So one thing that is essential for you to know when you're going to talk to an attorney is that knows what they're doing. And many special needs attorneys won't have an interview with you if you don't tell them all the benefits programs that the person is eligible for, because it's impossible to do a good plan because you may protect one benefit that you know about and then lose another benefit that you don't know about. Now, and another reason why we don't want to reduce the benefits for an SSI beneficiary, because with SSI comes Medicaid, right? And with Social Security disability comes Medicare, all right? So, and sometimes some of these benefits or the treatments and all are basically contracted out by the state and only available for people who qualify, for, Medicaid. On the SSD side, it's not really a problem if Medicare is going to be appropriate for the person. All right. So you want to know the program, you want to know the dollar amount, and you want to hang on to your current benefit statements from each of the programs that the person has. That's the easiest way to know. So there may be some from the state, there may be some through different programs. There may be, federal programs for SSI or Social Security disability. So make certain that you gather those and hang on to them at least until you get your next benefit statement. So let me move on. So know the other income sources that the person has too. All right. Many people get two kinds of benefits. They get SSD benefits if they have a work history which doesn't have many hours involved in it. And they may also have a SSI on top of that. And if you reduce the SSI portion because you give them a small amount every month, one thing I need to go back and tell you, and that is that a person can get both SSI and SSD benefits, all right? Usually, people on SSD don't get SSI benefits because the benefits are usually over the limit for income on SSI. So every dollar of income you have reduces that maximum SSI benefits. So if the person has a little bit of interest income and they get receive a little bit of income from a trust or something like that, it will reduce the SSI benefit. But if you're duly eligible, which means the person's getting both, you have to be additionally concerned, because if you wipe out the SSI portion, even though what the person's receiving is less than the maximum SSI, you wipe out the Medicaid benefit. Today, that's not as important as it used to be because of Obamacare, but they keep having efforts to try to get rid of Obamacare. And if they are and you're in that situation, it could mean loss of a significant amount of medical benefits. Now, for a supplemental security income basis, we went through that. It's Title 16 of the Social Security Act, okay? And the person has to be over 65 years old, blind or disabled in order to receive SSI benefits. So the most common way for special needs trusts is that the person's gotten a disability determination. If you've made application for a Social Security disability determination, and the determination for disability is the same for SSI and SSDI. All right. So if you have one, SSI, it becomes a financial item, whether or not you get the it's backwards. If you get the SSD, you may not qualify for the SSI because it would wipe it out. And that's why people, when a parent dies and they're receiving their benefits based on their parents' work history, it's generally large enough to wipe out the SSI entirely. All right, and you have to be a citizen or a permanent resident. That means with a green card. And you, as I say, SSI has those assets and income limitations. With Social Security disability, just quickly, there are disability income payable to those who have a work history. Eligibility is determined by a formula. You have to have a certain number of quarters, and basically it's 20 out of the last 40 quarters, but the Social Security Administration keeps track of that. And if you don't have the 20 out of 40, if you're disabled, you can still qualify for the SSI, but not the SSDI is the general rule for that. All right. But this is where the definition of substantially gainful employment takes place, where you, if you get too much money from earned income, it can basically make it so that you're not able to receive any SSDI benefits. There are work programs that allow people that want to go from disability status to an earned income status. So they will let you earn money. Those programs are generally supervised with someone that will check out that you have a plan to what you want to do to try to get back into the workforce. So Medicare for the disabled. There's also private health care and insurance, which may qualify someone. Now, before, when Obamacare, for most of us and for Connecticut, we had a previous law that wouldn't allow them to hold pre-existing conditions against people. But if Obamacare were to go away, or the Affordable Care Act, then the other programs under Medicaid that came in with Obamacare would disappear. And that would affect not only seniors and people under the age of 65. So there's generally a 24-month period between when you're first disabled and when you're entitled to get the coverage by Medicare. There are, it takes a person about an additional 5 months to get the Medicare benefit. So it can be a number of years and whatever. In that case, if you can't get the Medicare, you can still qualify for a Medicaid program. All right. We went through this before, so I'm not going to spend a lot of time on it. Let me see. So generally, the federal law provides that when the federal government is trying to collect back benefits from someone when they, let's say they receive inheritance or something, and in many states, the state agency will be notified that of who's getting who's a beneficiary of the estate, and in Connecticut, the Department of Social Services through their administrative arm would be able to put in a claim against the person for the amounts that were expended under Medicaid. It's important to know that that only applies federally for benefits that were received after the person reached age 65. But if there's a special needs trust involved and it requires any payback to the state, you have to pay everything back that the state has, not just the part that was received after age 55. Now, so let's quickly review. We've been through a lot of that. SSI usually has a limited work history, and SSD revolves around the concept of substantial gainful performance and a work history. Let me see. We went through that. Let's move on. All right, so it's likely that the beneficiary will need these benefits during his or her lifetime. And as I mentioned earlier, we have to decide, are we going to need these benefits enough to care about it? Because there are some things that you may not want to happen as a result of this. You may not want to incur management fees or something like that associated with administering one of these trusts if you don't have someone within the family. And a lot of times for special needs trusts, it's not a good idea to have a family member involved, because usually as trustee, because the family member, it's usually a brother or sister that's involved, has usually been that person's biggest advocate anymore. And now all of a sudden they're placed in the position that they have to say, no, you can't have this money for that because we need it for something else all the time. And that can create a certain amount of friction. So a lot of times, if you want the person who would be potentially the trustee to stay as the cheerleader and the advocate, then it might be a good idea to have someone else as the trustee and have them just confer with the sibling that's an advocate.
Would that be a lawyer, a friend? Who would you recommend?
There's no law on that. It's a judgment item. It could be an attorney. Many attorneys don't like doing that. It could be a bank or a trust company. There are some banks and trust companies that specialize in dealing with special needs trusts, and that know, because there are limitations, because if you pass out too much income, you could once again affect benefits if they go directly to the person, or if you spend benefits on the wrong kind of items, it could reduce and affect their benefits as well. And many times, if there are family members involved, especially if the person's disability is past beyond serious, the family members oftentimes don't have any resources. So they start paying for things. And then the question arrives is this for the sole benefit of the special needs beneficiary? Because generally during the terms of these things, there can only be one beneficiary of that portion of the trust. Okay, so, and then that, as I say, once again, you're trying to protect eligibility. So if you don't have a bank or an attorney as a trustee, then the trustees should be conferring with an attorney regularly so that when any of these questions come up, they can get advice that won't stop them from losing benefits. Now, sometimes you have to weigh whether or not the losing the benefits is warranted in your situation. All right. So one example is paying for housing. All right. For someone on SSI. And if we do that, we'll get a reduction. But for housing, it's not a dollar for dollar reduction. Our reduction is 1/3 of the maximum SSI benefit. So let's say at the time we're talking about this, the maximum SSI benefit is $900. Then a third of that, it's approximately a third of that, or $330 would be reduced. But if that allows someone to live in an apartment that they wouldn't otherwise be able to live in, it might be a bargain that you want to make. But if you give them the cash to say, here, go get your apartment, now the person's benefits are wiped out. So you do need advice. And a lot of times, the people that are operating it, both of the parents oftentimes are dead. So the other children don't always have any experience with the trust or how to administer it. So let's talk now about the different types of special needs trusts. Now, some of these trusts have different names that describe the trust. So, but if we name them based, the first two that are listed here, the D4 and the D4C trust, are basically named for the provision in federal law that provides for this type of trust. So we call a D4A trust basically a first party trust, because here we're always using the money of the beneficiary to fund the trust. All right. And you see this, if someone doesn't do the planning and a relative leaves the person $100,000 and they need their SSI and they need their Medicaid, then the way we can correct that is we can put the person's money into a D4A, what we call a D4A trust, and then if we do it appropriately, it won't be counted there as theirs anymore. So it may involve a 1 month problem, but it depends on how long it goes on before it gets into the trust and gets done. Now, the reason why we don't like the D4A trust, and you say, why don't I just give it to my kid and that they can put it in a D4A trust when the time comes. And the problem for that is if you have other types of beneficiaries, that you want to benefit after that person is gone. Well, with a D4A trust, there's an obligation to reimburse the state for the money that's been shelled out for the beneficiary during their lifetime before you can give the balance to any beneficiaries. So basically other children or grandchildren, all right? Another problem with relying on a D4A trust is that these trusts have to be funded by not established and funded fully by the time the person reaches age 65. And if you want to see something sad, see someone where we're waiting for, and a court approval is a lot of times required for these things when person's on a disability, or you have a family going through probate before the money can get into the trust, and the person reaches their 65th birthday. Now that may sound funny to you, but people are living till 90 now, or past commonly, and you know, it's a problem that I've seen in my practice on several occasions. So a D4C trust is what we call a pooled trust. There are certain situations where a disability trust won't work. First, it won't work when the person is over age 65, because even if it's already been set up, we can't put money into it anymore. So we also can have problems with the D4A trust, because it may be hard to get a court approval if that's required for it with the same language that we want to use as well. But with a so there are, or the state may be so small that it's just not economical to run a special needs trust and whatever. But we want to set some money aside for the person in some kind of special needs trust. Well, there are a D4C trust is a trust that's established by a charity that will use the person's assets, or sometimes even their income, and will set it aside for them. And the charity runs one of these funds for many people, and they will hold the money for each of them. They'll account for how much they've spent on each one. They'll allocate it. They'll take care of the paperwork and the document, and they will charge a small fee to set it up. And they will also charge an annual fee for getting the tax returns and things like that done. And they may charge hourly for additional related services, like if they have to have a social worker go out and determine what the needs are and things like that regularly, they may charge hourly for that. In Connecticut, there's one charity that's been authorized by statute to maintain a pooled trust. In other states, there's any number of them around the country that are run by various charities. Some of them are run by a support organization for a specific illness or condition, and some of them are run just by charities that are set up specifically to do that. If we put money in a D4C trust, we're limited in that any money that goes into that trust has to either go, when the beneficiary dies, has to either go to the charity that's running the pooled trust, or it has to go to reimburse the state. In Connecticut, the state generally is pretty firm that it has to go to pay them back and not to the charity. Other states aren't always that strict on that. All right. Now, I want to get to a third-party trust. Now, third-party trust is usually the best way to make this happen for setting aside benefits, because a third party, we would be using your assets or a grandma or grandpa's assets to fund a special needs trust for the child. Now, the big benefit of that, it can be set up for anyone at any age, number one. And number two is, after the beneficiary's death, the money is not obligated to repay the state. So the money can then go to the children or grandchildren or to a charity that you favor of your choice. So But remember, we have to do the planning. You can't say, well, I'll get around to it someday, and then you pass away. And then that introduces other problems as well. Okay. So for third-party trust, there's two ways to really do it. We don't like using last will and testaments to create them, even though we can, but then we have to continually report to the probate court, and all the assets you want to get into the trust have to go through probate. So usually we're looking to do this in two ways, either in a person's living trust, where it would say any money that's set aside for Johnny, I want to go into what essentially is a special needs trust, and at his death, I want it to be distributed as follows, okay? But there can be some problems with that because you can't fund that during your lifetime, because in a living trust, the trust says everything is yours, all right? So in a third, and sometimes we have other relatives who may die before us. Now, if they die after us, they can name your trust as a beneficiary of their estate or trust. But if, grandma or grandpa dies before you and wants to leave some money there, they don't have a vehicle to do that. It's additional expense for them to have someone go and draft this trust, and it makes it more cumbersome, and you may not have the choice over who the trustee is if it's grandma or grandpa's trust that is being set up for your child. So what we generally advise, if people know that their grandma or grandpa wants to take care of their special needs child at their passing, then we set up what we call a standby third-party trust. All right, and standby means we set it up now. It's a legal entity now. We put a little bit of money into it. In those states that approval is required, we can even get the trust approved now, because remember, in all of these situations we've spoken about up till now, we generally need approval of an agency or a court. And if we wait till your living trust is, special needs trust is funded, you'll be dead. So if we have a mistake in the language of the living trust, it becomes more difficult to change that later on. It's not impossible, but more difficult, because usually it's going to, depending on state law, we may have to once again get a court involved who thinks they have the authority to authorize the change. So by setting it up ahead of time and funding it with a small amount, you can get it approved by whatever agency that needs to approve it. And when whether you die before the other people that want to contribute to it, you'll know that there's a trust in existence for it. Before I move on, I just want to say you want to be very careful that if you have set up a disability trust, a D4A trust for our first party trust for a beneficiary, and it's funded, you don't want any of your own money going directly in there, because federal law is very clear, and this federal law applies in all states, that if you commingle a third party's funds with the first party special needs trust funds, all of it will be considered to be part of a D4A trust and will have a reimbursement obligation after the death of the person. So let me move.
So how are you doing there, Franklin?
Yeah, I'm going to skip one or two slides. There's a couple just quick closing slides. Please no. All right. So we mentioned the other people's money already, so we just covered that. All right. Now, when you're setting up a third-party special needs trust, the person doesn't have to currently be receiving benefits. A lot of times we have people that may have a degenerative illness and they're fine now, but sometime down the road, they may need the benefit. Then we just set up a trust, a special needs trust form. And the language basically says, well, you can use it for anything that a public benefit won't pay for. Well, if the person's not fully disabled yet, or if they still have resources of their own they're hanging on to, we can still have money set aside, so if they do need it, the benefits in the future, the money's protected. We don't have to worry about look-back periods or anything, or other eligibility issues. Okay, standalone. We went through most of this already. All right. And that's the end of the presentation.
Did you have,
A little longer than we had scheduled, but that's what happens when people ask good questions.